And so we saw throughout history, people have been claiming that this enemy, the enemy I'm fighting right now, is not entitled to protection. And then we saw we had the Holy Wars and Crusades, where the code of chivalry was only applied between Christians, it didn't apply to non-Christians. That system doesn't work, and it produces atrocities. Another argument from the United States is that we're in a war on terror. This is a crisis, and in this crisis, the gloves must come off. But that's the whole point of humanitarian law. It's always a crisis. It's always a conflict. It's a war. The enemy that you're fighting is always the epitome of whatever at the moment. So that's the essence of humanitarian law. Now, there is a more sophisticated and legalistic argument from the U.S., which I want to put to you. And they base it on Article 4 of the Geneva Conventions. And that's the article that says who gets to be a prisoner of war and who's not. You can be a prisoner of war if you're part of a regular army. A regular army is like the Canadian Army with a recognized government and so on. You're a prisoner of war if you're part of a regular army, even if your government's not recognized by the other side. In addition to that, you might be part of some irregular force, but in that case you have to meet 4 requirements. You have to have responsible command, you have to carry some distinctive sign so that we know that you're a soldier, you have to carry arms openly, and you have to respect, you have to comply with the laws of war. The U.S. says Al-Qaeda doesn't comply with the laws of war. Now, that argument is actually, there's some credibility that there's, as I'll explain, there's pros and cons to characterize in that way, but that argument is credible enough. What is more strange, and I'll just touch on, but the U.S. says the same thing about the Taliban. They also be prisoners of war. Now that's strange because the Taliban was, whether you like them or not, they were the government in Afghanistan. But the U.S. says, we don't recognize them as part of a government or authority that we don't recognize. And there's a logical, some of you see there's a logical contradiction here. Your recognition of non-recognition is not a requirement. They also say, well, the Taliban don't comply with humanitarian law. And what we want to do is we want to cut and paste those 4 requirements I listed, and we want to also apply those to regular armed forces. So the argument is a literal, strict textual reading where that suits, or it's a creative, leaving the text argument where that suits, whatever it takes to minimize or exclude the protection of humanitarian law. And we have to be very careful about that kind of reading. In 1974, Professor Richard Baxter said, the first line of defense for people who are trying to avoid humanitarian law is they deny its applicability. Now the U.S. argues that the conventions are a bargain, they're a basis on reciprocity. If your side's not complying with humanitarian law, you don't get the protections. And it's interesting, but there's severe risks associated with that. And that's why this idea of strict reciprocity, it was abandoned a long time ago in humanitarian law, because what you get is both sides accuse the other of not following humanitarian law, and then both sides say, now I don't have to comply with humanitarian law, and you wind up with massive atrocities. So today, there's 2 bases for humanitarian law. One is reciprocity, but the other one is our own respect for humanity, our own respect for values. And there's another problem is that if we go this line that the current administration is arguing, then it's open to other forces to say, well, the United States doesn't comply with international humanitarian law. They could look at images from Abu Ghraib or things coming out of Guantanamo, or maybe there's some collateral damage that they think is excessive. So they could say, the United States doesn't comply with humanitarian law. Therefore, its soldiers are unlawful enemy combatants, and that means we can torture them and do whatever we want. There's a bigger problem than what I just listed, though. And the bigger problem is that you have to pick. People are either a civilian or they're not a civilian. It's A or not A. If they're not civilians, then you treat them as combatants, and that means you can hold them until the conflict's over, but you have to give them all the rights of a prisoner of war. You can't prosecute them for fighting. You can't interrogate them, and so on. Or you can treat them as civilians, and that's fine. If they're civilians and you want to apply the criminal law model, they're criminals and I'm going to prosecute them, that's okay too. But then you have to give them the rights of civilians, the rights of human beings. So that is, you can't be held without being charged. You have the right to counsel. You can't have indefinite detention. You have to give speedy trials, habeas corpus. They can see the evidence against them. They can respond to the evidence against them. They get a fair trial. It's one or the other. But what the Bush administration does is it shifts It shifts between the combatant model and the criminal model whenever it looks like there might be some rights that have to be respected in the other box. So you don't get the rights of a combatant because you're a common criminal. You don't get the rights of a common criminal because you're a combatant. You don't get Geneva Convention 3 for prisoners of war, but you don't get Geneva Convention 4 for civilians. You fall between the cracks. You're under Geneva Convention 5. There is no Geneva Convention 5. That's too bad for you. I guess there's no rules. Now, I have to modify what I just said and clarify a little bit because it's not a complete absence of rules. More recently, after the Hamdan decision, the Bush administration acknowledges we have to respect Common Article 3, which Bill mentioned. These are these minimum standards. But they give it and then they take it away. They take it away by saying the president is the sole authority to decide what Common Article 3 requires. You can't raise Geneva Conventions in the courts, and we're going to block access to the public, so there's not going to be public, we're not going to have public opinion on whether we're complying either. And so far it sounds like Common Article 3 allows detention forever, without charges, interrogation every day, and measures that are considered cruel treatment or torture by people other than the Bush administration. Now I've gone slightly over what I meant to do. I've only looked at this adjective unlawful. I just want to touch on this word combatant as well. Their definition of unlawful enemy combatant doesn't even require you to be a combatant. To be a combatant, you have to participate directly in hostilities. Makes sense, that's the word combatant. The U.S. says it's enough if you provide material support to Al-Qaeda or groups or groups associated with it. So if an old lady sends a check to some group that is associated with Al-Qaeda, she is a combatant. If some guy in this happened in Peoria, Illinois, credit card fraud, some link to Al-Qaeda, he's called a combatant. He's an unlawful enemy combatant. If you bought war bonds in World War II, you're a combatant. This is making a mockery of language and hence a mockery of law. And I think this policy of rewriting humanitarian law, it's bull-headed, it's ham-fisted, and it's short-sighted. This is the opinion segment, though. It's bull-headed because it regards law as an irritant. It's something you have to work around, not as something that protects our values. It's ham-fisted because they're so obviously twisting the rules, so transparently and obviously twisting the rules to get whatever result they want. And you see all these mistakes that come out when you invent law as you go. And it's short-sighted because it's not thinking of the harm to U.S. reputation and credibility. And now the very last point is Omar Khadr was 15 years old at the time that he was taken into custody. We have child soldiers in the world who have mutilated civilians and they've butchered entire victims. They don't comply with humanitarian law. Their armed forces don't comply with humanitarian law. But we tell them, you were children, you were the victims. The wrongdoer are the people who used you, the people who recruited you and used you in this way. And we spend money on their reintegration. Now, Omar Khadr is a child who was indoctrinated in a group that we don't like, by our enemy. So then what happens to our principles? What are we going to do for Omar Khadr?
Jen.
Go back to something that Nehal said in his introduction, which is that the problems with attempting to create an entirely new alternative system of justice. In 2001, soon after 9/11, President Bush issued an executive order, and he said he was going to create an entirely new system of justice to try the worst of the worst, the most dangerous suspects, the people who the masterminds, the financiers, the most responsible, reprehensible people who were responsible for blowing up the World Trade Centers and killing thousands of people in the United States. It's almost 6 years later. There has been one trial of one person. It wasn't even a trial, sorry. There's been one conviction, a guilty plea, by a man, David Hicks, who's now home in Australia, about to finish out his 9-month sentence. Every other trial has started and stopped. First, because the Supreme Court stepped in and said, you can't do it this way. These rules are illegitimate. This system doesn't work. And now most recently because Congress, when it responded to the Supreme Court's ruling and tried to create a new ad hoc system of justice, messed it up. It's hard to create a new system of justice. Congress said, Congress gave the military commissions the authority to try what are known as unlawful enemy combatants, but predicated their trial on a determination that they had been just enemy combatants without the jurisdictional the military commission stopped. for the time being, because it's hard. It's hard to get the procedures